Hi, everyone. Thank you for joining us today for Constangy's webinar, Decoding Discrimination Laws, What Employers Need to Know. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave time to answer your questions. This program is approved for SHRM and HRCI credit. We will be sharing those codes at the end of this presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Joyce and Joanna.
Hi, everybody. My name is Joanna, and I'm so glad that everybody's here in attendance. I am a labor and employment partner over at Constangy Brooks, and I practice primarily in California, but I also practice in New York.
Hi, everybody. I'm Joyce. I'm in Constangy's Boston office. I'm an associate. I practice primarily here in Massachusetts, but I will, sometimes star in a different state as necessary, and I represent clients through all phases of litigation.
So let's get started. So basically what we're going to be doing today is we're going to be offering a very broad overview of discrimination. It's a broad topic. Basically, Joyce and I can sit here until dinner time and discuss this with y'all. I know that we don't have the time to do that. So it's going to be a very general presentation. But what we're going to do is we're going to cover topics such as, what is discrimination? Why should we care about discrimination? The consequences of not caring about discrimination, or even if you do care about it, what can happen? Worst case scenario. We're going to go over instances of what protected classes may be, not only under federal laws, but state laws. And we're also going to talk about handbook policies as well as other written policies that can provide the best line of defense whenever any sort of discrimination complaint or lawsuit comes around. And we're also going to talk about workplace investigations and some best practices to address any complaint of discrimination that goes on in the workplace. And so with that, we'll begin the PowerPoint.
So first and foremost, what is unlawful discrimination? So I think before we even get into that, we need to start talking about at-will employment. So the default rule in the United States is at-will employment, which means that both the employer and the employee can terminate an employment relationship at any time for any reason or for no reason at all, unless the law prohibits it, such as a termination for a discriminatory reason, a contract modifies it, like a collective bargaining agreement, or a statutory scheme already exists that regulates how the employees may be disciplined or terminated, such as is common for federal, state, and local government employees. And this very broad discretion also extends to other kinds of adverse employment actions, such as declining to hire an applicant or even to promote an existing employee.
So basically what this does is, even though employment relationships are at will, well, that doesn't mean that you can just fire somebody or engage in an adverse employment action just because you feel like it. At will is a little bit of a misnomer here, where what we are prohibited from doing, what is considered unlawful conduct on the employer's part, is discriminating against an employee based off of their membership in a protected class.
And so why do we care? Why do we care about unlawful discrimination? Well, so most employers are subject to federal laws prohibiting employment discrimination, as well as local and state laws, but not everyone appreciates the related legal risks. So you can even see, so in 2022, the EEOC received over 70,000 individual charges alleging discrimination. Employers sued for discrimination face really large financial losses, even if you win. So it is really important to pay attention to these laws and implement good policies so that we can address them as they come up.
That's correct. And so, going into the impact of these lawsuits, and granted, there's different stages of the litigation process, but like, let's say that, you want to take a case all the way to trial. Okay, well, the jury award, let's say that the jury decides to come up with an adverse ruling to the company. Well, that jury award can include, significant amounts of money where it includes front pay, back pay, compensatory damages, punitive damages, which are actually meant to punish the employer for whatever conduct is alleged to take place. Injunctive relief, where in some instances there's actually a court order where the employee is reinstated back to work, even though they were fired, for whatever reason. And the award also includes attorney's fees. Now, the attorney's fees thing is a critical component here, because whenever there is any sort of a discrimination lawsuit, usually the plaintiff's attorney or the employee's attorney takes that case on something called a contingency fee basis, where whatever award is amounted or awarded, whatever settlement amount there is, what basically happens is that plaintiff's attorney takes 30 to 40% of everything involved. So let's say that there's $1 million jury award. Okay, there's usually attorney's fees on top of that. But even if there's a settlement, that plaintiff's attorney is going to be taking 30 to 40% of the total sum. And so that's big money for a plaintiff's attorney who decides to represent, the little guy. A lot of times, let's be honest here, the plaintiff's attorney doesn't care about the employee. What they care about are the fees. And so what they're going to do is everything in their power to maximize the amount of fees that they're able to recover for doing the least amount of work possible. However, there are very aggressive plaintiff's attorneys that we found. There's a couple of pretty famous ones here in LA where I practice, where they will take innocuous or what appears to be a very innocuous discrimination case, and they will turn it into a full-blown jury trial where they are excellent at creating something out of absolutely nothing. And so even if you're an employer where you want to vindicate your rights and you feel very strongly that the company didn't do anything wrong, you take this all the way to litigation, up to a jury trial, and at that point, you lose a lot of predictability. You don't know where the jury is going to go. I know that Joyce and I have a lot of examples on that, but even then, this is just a very risky proposition in general.
Yeah, and to piggyback on, the jury component side, a lot of times when we are working with clients and employers, we hear them talk about their case and with conviction because they believe that they did nothing wrong and that no discriminatory conduct occurred. I cannot underscore enough the unpredictability of a jury award. I participated in a trial this past year, and a couple months before that, we did a mock jury because we wanted to test our legal theories out before some jurors from the same kind of pool. The case was filed in Suffolk County, so we had pulled people from Suffolk County to be part of this mock jury, and we got to watch them deliberate after we presented all of our evidence. And it was really shocking for me to see how the thought process was for some prospective jurors. Like, for example, we had gotten 2 defense verdicts in our mock jury, and at the end, there were 2 people who were really fighting for the plaintiff, and we polled them and asked them, hey, why, given everything that you said, why did you still want to fight for the plaintiff? And, one person said, well, I don't think discrimination occurred, but this guy worked really hard for the company and he made them a lot of money. So I thought that $500K seemed reasonable. And that is not reasonable. It was contrary to the law. It was contrary to the facts, but that is kind of the risk that you run. So, and then when we talk about, let's say you win, well, how much does it cost? What are you looking at in terms of attorney's fees? So first of all, the cost to defend a discrimination lawsuit can vary widely based on a number of factors, including the complexity of the case, the jurisdiction, and the duration of the litigation. But these figures on the screen right now are if you win, and they're averages. So defending a case through discovery and a ruling and summary judgment, that can be anywhere between 75 to 250K. If you lose summary judgment and have to go to trial, you can tack on upwards of another $500,000 onto that, and you can always expect appeals. You will never be done at just just a defense verdict, you can almost certainly accept appeals. And then you can add that on top of any other verdict to follow.
And granted, we're quoting figures if assuming that you don't have EPLI coverage or full EPLI coverage. And prices vary widely. A lot of times employers decide not to go with EPLI coverage for their own reason because they don't have control over their counsel and how their case is going to be handled. It varies very widely. But even if you are going through EPLI coverage, and granted, I'm not an EPLI expert by any means whatsoever, but what you do want to look at is how your employment counsel is going to handle the case, and they're not going to excessively litigate. They're going to pay attention to you. If you want to go to early settlement for business reasons, you're going to go there. If not, if you actually do want to go to trial and the insurance carrier is behind it, then they're going to listen, and they're also going to give you their best advice and recommendations. But generally speaking, here the point that we're trying to make is that discrimination claims are a very risky proposition where you're not only going to be paying attorney's fees on the defense side, but if there is any settlement reached or a jury verdict, or anything else, then at that point, you are going to be paying potentially even out of pocket. And so we wanted to make that clear. Now, in terms of settlements, one thing that we want to mention is there's a lot that goes into determining a settlement amount for an employer, where basically what we do is, or what attorneys are going to look at is, the individual's salary. Let's say that we're dealing with a highly compensated worker from, a huge nationwide bank, for example, who is a professional in their field. They earn, I'm throwing a number out there, $400,000. Okay, well, that entire amount is going to take into consideration front pay, back pay, and everything's going to go off of that. We're also going to look at the witnesses, the conduct alleged, basically the facts, that are pertinent here. But another big factor too, and I've already touched on this before, is really how aggressive opposing counsel is. Some of them want to settle the case. It's very much of a wham, bam, thank you, ma'am, we're done. Let's just get out of this. Here is the settlement agreement, done, done, done. Other attorneys, they want to take the depositions. They're going to be taking, the person most knowledgeable or, the company representative deposition. And that takes at least 2 days, for each witness to really prepare for, for being somewhat conservative. And we're just talking about, very run-of-the-mill cases where they're not, especially complex, or there's, no evidence of really intentional wrongdoing. It doesn't shock the conscience. It's not super egregious behavior. But generally speaking, just in my experience, settlement amounts, do vary widely, where they can be, in my experience, up to $1 million. I have settled some discrimination lawsuits for under 5,000, but it is very, very situational. And it depends on the facts involved and the litigation stage and whatnot. One other note that I wanted to make is that even if there's a settlement agreement where the employee needs to keep things as confidential, they don't always do that. And Joyce, I think that you had a really good anecdote about that.
Yeah, I think so. This is another good point of why it's really important to, discuss these cases and, potential claims of litigation as they arise with your employment counsel, because there's no guarantee that an employee that you settle with is going to keep a settlement amount or that a settlement occurred confidential. There are, not that long ago, I had a situation where, the company settled with one employee, and then that employee had been terminated. They settled with that employee, but that employee was still really good friends with 3 or 4 other people. And then within the next 6 to 8 months, we saw similar claims coming up for all these other employees that were very close friends with the plaintiff.
What a coincidence.
Yeah, we were shocked. There's no correlation whatsoever.
No.
So that sometimes factors into, your strategy for how you're going to handle one of these claims. And there's also, don't forget the non-monetary costs. The litigation takes on average 2 to 4 years. The case that I took to trial last year, that took 7. And during those 7 years, there were so many days where I had to work with managers, executives to prepare them for depositions, to prepare them for trial. And that loss of employee time, every minute that they were working with me, they were not doing their jobs and furthering business objectives.
Yeah, and what I find with a lot of employment discrimination claims is once you start going into the facts, these claims or these lawsuits can become incredibly complex and very fact driven, where it becomes a matter of selecting, what facts favor, your arguments that you're going to make on a motion for summary judgment, which you want to win on, as an employer before trial. Because then it does away with the obligation to go to trial. But generally speaking, this is just a risky proposition, and it's better, to prevent these lawsuits from occurring in the first place. And so, as a preliminary matter, we should go over, the federal laws and state laws that govern workplace discrimination.
Yeah. So, the federal laws governing workplace violation, there are many. Here are the big ones, though. Title VII of the Civil Rights Act. That's what makes it unlawful for an employer to discriminate on the basis of race, color, sex, religion, national origin. The Age Discrimination in Employment Act, the American with Disabilities Act, the Equal Pay Act, FMLA, and for every federal regulation, there is certainly a state equivalent, and often even local equivalents. For example, New York City has broader protections than New York State, and New York State has broader protections than the federal laws.
That's absolutely correct. And so a couple of points I want to make here are always pay attention, to, the state corollaries of, discrimination laws. A lot of times where companies run into issues is when there's, a federal law on point, but then a state law says something different. Okay, well then which one, actually should you listen to, so to speak? Usually what we say is, okay, the state laws are going to typically really offer broader protections in this context. But sometimes, let's say that the state law is silent, then you have to go to the federal law for advice, on, whatever issue you might be tackling. And this is very fact driven. It depends on the circumstances. It depends on, the particular issue that you're dealing with. But, we all do have to be, privy to, okay, federal laws and plus state laws. Generally speaking, with the federal laws haven't changed all that much, but we have seen a lot of movement in that regard, where, even in 2023, now there's the Pregnant Workers Fairness Act, where it requires employers to grant reasonable accommodations to qualified job applicants for known limitations related to pregnancy, childbirth, and related conditions. And it also prevents or prohibits discrimination against job applicants or employees because of their need for a pregnancy-related accommodation. Now, this is probably something that is not going to be a very popular topic, but I have seen this manifest into a lawsuit where, let's say that an employer hires a new employee. She actually, my sister's guilty of this too, but she comes in and she's wearing a big blazer and everything looks great. And then she actually starts, oh, by the way, I'm pregnant and I'm due in a month. Now, what I always say, on the advice and counsel front is put on a big smile and say, congratulations, and say, okay, let's get the FMLA paperwork together. Thanks for letting me know. We're on it. There should be a canned response. But, a lot of times what will happen is the supervisor or the HR representative kind of responds in shock. I've seen a lawsuit where it's, why didn't you tell us, before, which indicates, okay, we might have not hired you had we known, you know, the circumstances. And that's absolute, you know, discrimination. But discrimination can also occur in other contexts.
And as we touched upon, you know, the states may offer broader anti-discrimination protections. These are, so we think age is typically in the federal, at the federal level, it's 40 years or older, but it's in a lot of states, it's also 40 years or younger. In some states, it's as young as 18 years old or younger. You know, as a former 18-year-old, I don't think I have that much problem with, you know, discriminating against 18-year-olds, but, you know,
I used
you
to
should
say,
be
yeah,
aware.
I'm young. Isn't it great?
Yeah, and if your brain has not fully formed, you might not make the best decisions, but you need to be aware of these broader protections that many states offer. And you also need to frequently check state laws for legislative updates. This is incredibly important. These laws at the especially at the state level, is very frequently a moving target. Massachusetts, for example, right now, there's a proposed legislation that would create really broad workplace protections against bullying and abuse at work. And as you can imagine, the legislation right now as proposed is defined really broadly. So that would include, and is not limited to, you know, conduct that, you know, that might include what someone could perceive as verbal abuse, use of derogatory remarks, insults, threatening, intimidating, or like or something that was humiliating. Now you can imagine how this conduct is going to be incredibly subjective. So that's why it's one of the many reasons why it's important to check your state laws for updates. And if there's one place I am happy that I only practice a little bit in, it's California, because of, for many reasons that I will let Joanna explain.
So I always like to say that California and New York, we like to keep things complicated here, and certainly discrimination laws, it's not an exception to the rule. Where, you know, one thing that has really received a lot of buzz, if you will, has been the new marijuana use law, where now California prohibits employment discrimination based off of an employee's off-duty marijuana usage. And so basically it means that, you know, when you have an applicant, you know, for a new job position, usually you test for non-psychoactive metabolites. Yes, I got it right. But it's a little bit of a mouthful, but basically, you know, employers always included that, you know, as part of their panel screening, especially for employees that are in more safety sensitive positions. But now, you know, under this new law that basically it creates a protected category or a class of people based off of their actions, which is smoking pot recreationally. So, you know, historically, you do, you know, tests, you know, to the extent that you do drug testing. A lot of companies, most companies do. They're going to look to see whether you have, you know, any remnants of marijuana or THC in your system. Now you can't do that unless you fall under a very, very narrow exception. Now, Colorado, Nevada, Washington State, they all have laws, you know, where it does protect off-duty marijuana use, but there are safety sensitive exceptions, you know, to the rule. Even Colorado says, hey, the employer can determine whether a job position is safety sensitive or not. Well, here in California, there is no such thing, where basically the only way that we are able to test, you know, for marijuana or non-psychoactive metabolites in somebody's system is if somebody's in the building or construction industries, which is kind of a weird thing to, you know, single out. But also if somebody carries a federal license or there's a federal contract where, you know, the employer would be in violation of that, but they are very, very narrow exceptions. Another kind of newer law in California is reproductive, you know, healthcare rights, where let's say that an employee decides to go through IVF or decides to terminate a pregnancy, you know, for her own reasons, or even let's say that, the woman doesn't want to terminate her pregnancy, but found instances of a trisomy 16, Down syndrome, whatever it may be, and decides to terminate. Well, now employers in California can't discriminate, against the employee, for going through IVF or making these reproductive healthcare decisions. So that actually does change the trajectory a little bit, where it's somebody's actions that actually dictates whether, they are in a protective class, where the IVF one is actually interesting because beforehand, a lot of women would keep that very quiet and would try to go into doctor's appointments before work. But now, hey, if they need to go into the doctor every other day because they're going through IVF, then that's something where we have to be very careful not to do anything that could be perceived as being discriminatory. Another broader state protection is your association with somebody from a protected class. And this is how state law becomes so much broader. And unfortunately, state laws are not the same whatsoever. They pick and choose the laws that they want. But really, this area of law is ever evolving. It's always changing. And so it's always a good idea to, sign up for, our news blasts, because we do discuss important legislative developments that occur, but also, check in each year, make sure that you're subscribed, to, publications that do, blast us out like ours, because it's really important to be apprised of this. And it's not, these legislative developments don't necessarily occur January 1st of each year. Sometimes they occur mid-year and they don't receive a lot of buzz and nobody really knows about them, it's even in-house employment counsel. So please be wary of that.
Yeah, and as we were discussing, all these broader categories of protected classes and all of these new laws that are coming up, you need to be concerned with when is there liability for the company. So so you may say, hey, I didn't know about this law. And more often than not, that's not going to matter. There's going to be liability for the company if the company knew or should have known that conduct occurred, if they knew but failed to take prompt remedial action. And there's also liability for the company if the conduct was by a supervisor, because that is what attaches to the company is strict liability. That means the company is responsible for what the manager did. So how do you protect your companies from this really quickly changing landscape? Well, it first starts with a really great and really well thought out employment policies. So your company's policies are guidelines that outline your employees' expectations, the organizational obligations, disciplinary procedures, and behavioral standards. They are mandatory in many states, but where they are not, it is still highly advisable that you have a host of really robust policies.
So guess where these employment policies are mandatory? California and New York. And there could be other states, but I usually focus on these two. But generally speaking, what every lawyer on the defense side who does anything discrimination related is going to tell you is, hey, you better have written policies in place about this, is because it's really your first line of defense. It outlines, how companies, deal, with, discrimination or any sort of prohibited conduct that occurs. It also deals with, external complaint procedures. Again, California and New York, in the
not optional.
Yeah, themselves, they actually have to name the federal or the state agency where the employee can go to launch an external complaint if they don't feel like the internal complaint procedures are sufficient. And so it's really important to have those internal complaint procedures written down, and you should distribute them, to all employees as a best practice. Now, if there's no written policies, guess what's going to happen? So first of all, there's going to be a lot of ambiguity as to how to deal with certain practices. Companies, are all sizes, big and small. Even with the smaller companies, there's no written policy in place. Well, there's no guarantee that there's going to be consistency in the way that situations are dealt with, even if they're very analogous, right? And then that lends itself to a jury, or a plaintiff's attorney even really interpreting it as discriminatory conduct, because chances are, somebody got the short end of the stick, who was a member of a protected class, because again, protected classes are broad. And so you always want everything written out. You want everything to be laid out in detail, where you include a list, of all protected categories of, employees, not only under federal law, but under state laws. Now, a lot of employers, they're functioning on a multi-state level. And this creates some problems with the remote workforce, which we can talk about in a second, where after COVID-19, everything is a little bit more mobile, and working from home is definitely a thing. I can tell you from staff members here at my own office. they want to be remote all the time, and I say no. but basically what we want to do is list out all the protected categories of employees under the federal law. And to the extent that you're multi-state, what you want to do is maybe have a state specific addendum, so you really do address those little intricate details that might not be present, in other laws like reproductive health rights, which is very much a California thing. You just want to be state specific. You also want to include language, or make sure that, any policy that you have that's EEO related has some, kind of, a catch-all, phrase where it's, hey, here are all the protected categories where we prohibit, harassment, discrimination, et cetera, or any other characteristic protected by federal, state, or local law. And so that way, if there is a law that passes and you don't want to be updating a handbook, which again, we'll get to in a second, you don't have to immediately update your policies, or else that's going to be very burdensome, from an administrative perspective. And so sometimes you want that catch-all language to be a little bit broader. Of course, this is very common sense. You want to expressly prohibit any form of unlawful employee harassment. You want to explain that the policy prohibits unwelcome conduct. That could be a little bit broad, but you still want it written down. And you also want examples, which are not an inclusive list. You actually want to say that this is not all inclusive. These are just examples of conduct that violates the employer's policy. And so employees are adequately on notice of, what, discriminatory conduct and harassment may look like, because it's not always obvious. You want to say that the policy applies to conduct over at offsite work events, because you have no idea how many of these Joyce and I both get, where let's say that there's a supervisor and a subordinate, they decide to go out to drinks, one thing leads to another, and somebody is going to the HR department that following Monday, assuming that they went on Friday, and there was unwanted conduct that occurred, and usually drinking is in the mix as well. And so you want to, make sure that you have something that, says, hey, even if you're off site and you're off work hours, you are still expected to act a certain way. You want to explain the consequences of violating the policy. And you want to be very clear about it, where you don't want to say something in the policies where it would be, if you are found guilty of harassing, we will terminate you. No, you want to keep it a little bit open-ended, but say, hey, you will be subject to discipline up to and including termination. You always want to make sure that that language is there, so you can react to the different situations, the different circumstances and nuances, that might be presented. You want to impose a duty for all employees to report any instances of conduct that they believe violate the policy. So that way, if there is a lawsuit that, ends up happening and they never reported, the unwanted conduct, we can ask them, well, you got this policy here. Why didn't you report it? You said that you understood it. And so you definitely want to have that, as well as a duty to cooperate in any investigation that, takes place, because we get a lot of workplace investigations where even witnesses don't want to say anything. They don't want to rat somebody out. They don't want to be perceived as the rat, or maybe they're too scared to say anything, or they don't want to get involved. They don't want problems. And so you want it written down. Hey, you know what? You do have to cooperate with us. I do have the right to ask you questions, and I do expect truthful answers. You also want a code of conduct and an ethics policy, which is kind of related, to the EEOC and anti-harassment, retaliation, and harassment policies, because it really does cover expectations as to how employees should treat one another. And it's also a good place to put in how to approach romantic relationships in the workplace, which are very commonplace. According to a survey I saw on Google, so it's very, very precise, obviously. If nowadays millennials, don't see workplace romances as a big deal, but they are a big deal because a lot of times romantic relationships go south. And if somebody's working in the same department and they didn't report, that romantic relationship, and it goes awry, then that can lend itself to a discrimination claim. A lot of times, and this is very situational on the precise company involved, but some companies, especially large international employers, I worked for one before, they actually kind of are okay, actually almost encourage workplace romances, so long as it's not a supervisor to employee relationship and they're not in the same department. Because if you transfer overseas, then it's a lot easier to transfer your spouse as well, because you can, put them in a job within the same company. But generally speaking, it's just, if the employer doesn't want to put a complete ban on romantic relationships, then they can consider a love contract where it details, what's going to happen if the relationship doesn't go where it was intended to go in the first place. They could do a partial ban on relationships, but what I always recommend, to the extent permitted by state laws, is HR cannot have romantic relationships in the workplace, because that will create a conflict of interest so huge. And I've seen it too many times where we have to, at that point, we have to go with a third party workplace investigator, and everybody is upset and everybody has interacted with this HR person, and it just becomes a very messy situation. So I highly recommend, to the extent that it is permitted by your state laws, to put in that ban over for anybody really in HR. Sorry to belabor this, but I feel very strongly about these policies.
No, and they're super important. The company's employment policies are almost always my exhibit A to my position statement, because I want to show that the employer had policies. I want to show that they implemented them. And more often than not, a claim of discrimination or retaliation follows on the heel of an employee being maybe disciplined for performance, terminated for performance, maybe they're disciplined for misconduct. So having these policies in place that shows that they had, avenues for reporting harassment and discrimination and didn't do so is super important. So, and that's usually my exhibit B.
Yeah,
is the fact.
But again, I cannot tell you the number of times where somebody knows that they're about to get terminated, or they got heavily disciplined or whatever. And then, oh my gosh, all of a sudden there has been this ongoing harassment thing for this last year. It's been very pervasive. What a coincidence. Wow. And so one thing that we have to be very wary of is, like, Joyce was about to say, and I interrupted her, I'm sorry, is reporting procedures for all employees.
Yeah, so with regards to, so you have these policies, it's not enough to just have the policies. You have to have avenues for the employees to report them. And you have to give them more than one. It could be your supervisor, their next level supervisor, HR, a legal department, a hotline. These are all, you want to give them various avenues for reporting, and we'll get more into later on what you should do once you receive a complaint. But again, this is a prophylactic against litigation and avoiding these litigation costs for your company, because very often an employee knows that they know that they may be about to be fired, and then they will all of a sudden file for FMLA. And all of a sudden they will complain that their supervisor has been really exacting to them, and that conduct is tantamount to harassment or discrimination. And it is really helpful if we can show that A, we had these policies, and B, we had really clear avenues to report them, and they did not do so until they received the disciplinary action.
That's correct.
And go ahead, sorry.
Oh, and I also wanted to mention that a lot of companies decide to put in hotlines where somebody can file an anonymous complaint. A lot of employees actually do feel comfortable with this process, whether it's anonymous or not. But I will say that there have been enough instances where there's an anonymous complaint that names some individuals specifically and describes some conduct. And upon a mini investigation, we find out that it's true, and we're actually able to nip it in the bud, before it actually becomes, a full-blown workplace investigation where you have to follow certain procedures, but you do want to act upon those anonymous complaints.
Yeah, really important point too. So now you have these policies, you have these avenues written out, then the worst thing you can do is to not consistently disseminate these policies to your employees. These policies should be in your employee handbooks. They should be distributed to all new hires. They should be distributed to current employees on an annual basis. Employees should be acknowledging receipt of these policies and say in the acknowledgement to say that they read and understood them. You should have trainings. Certain trainings are mandatory in certain states. And for these more important policies, we also very frequently recommend that you have them be a standalone policy so that an employee can't say, I didn't know about this because this was buried in an 80-page handbook. Or I only saw this when I was hired and I never looked at it again. This is how you kind of, you show that. And then, my exhibit C is going to be that they received these policies, that they attended these trainings.
Yeah, and I have an ask for everybody who is in HR or legal or wherever, or an owner of a company, whatever it may be, to the extent that you have control over this, please make sure that you save each employee acknowledgement and put it in the personnel file and have a written policy on that even, because there are so many times where we receive a completely bogus discrimination claim. And I know that the employer, part of their onboarding process, granted, a lot of it takes place electronically now, so it's easier, but there are a lot of legacy employees where they started in 2005, and lo and behold, I know that there was a handbook then. I know there was an acknowledgement because other employees signed it, but they managed to lose the one I needed. And at that point, we don't have a line of defense. The employee can say, I don't know what you're talking about regarding the handbook. And so that actually, it creates a huge issue. Another thing is, like Joyce said, roll out those standalone policies, but also roll out new handbook versions, frequently, year end or at the beginning of each year, try to make it a goal to roll out, a new version of the handbook. Once you have a good version of the handbook in place, if you update it each year, it's not going to take a massive effort. Too many times I see a handbook where the last revision was 2015 and it needs to be massively, just revised. And a lot of times, any kind of third-party provider that isn't an attorney, they're not really going to customize it or use the right language. I catch instances of wrong language being used all the time. And so, we do want to do this incrementally. Another thing to pay attention to is pamphlets. A lot of states like California and New York are darlings. A lot of times they require, postings and pamphlets to be, disseminated over to employees about discrimination or anti-discrimination practices. Lastly, trainings. A lot of states, again, California, they do require supervisor training and employee training on harassment and issues of the sort. As far as trainings are concerned, there's non-mandatory ones, which we can get into in a second, but bias training or elimination of bias training or unconscious bias training, does become something that you may want to consider providing, especially to your supervisors. And so they know that they're more likely to become aware of them exhibiting favoritism in the workplace that may be based off of a protected characteristic.
Yeah, and another word on handbooks, please don't download one offline. I've had clients do that in the past. It is a lot more work for an employment attorney to mark up a handbook that they found online, whereas if they were just to create one for you, because we have good ones that might be applicable, it might be easier to customize.
And tailored to your workforce.
Yes, yeah. And with trainings, a lot of times, discrimination complaints are from within people, or from within groups that, are within the same group that, they may be under the same umbrella term. Like these employees might be broadly considered Asian, but they might be Southeast Asian. And you don't want to and you want to make sure that there are these implicit bias trainings, because that really, again, is not only helping you maintain a more equitable workforce, but again, it is preventing litigation.
That's right. And then one thing that I do want to mention is, as far as updating handbooks and policies and whatnot, let's say that you have a standalone anti-discrimination or EEO policy. And let's say that that doesn't need to be updated, but the rest of the handbook does. It's very much a situational basis as to what needs to be updated, in the handbook, because the handbook is comprehensive. Some employers call it a manual. We usually call it a handbook to address a comment, here. But, sometimes if you have like a separate state addendum or state addenda, you don't have to update certain state addendums, depending on, on what took place in the legislature. So I just wanted to address that really quickly. Now, as far as, training managers, Joyce, I think that you were saying something about that.
Yeah, so again, now you have you have all these great policies, and you're training your employees on how to, the proper procedures for reporting a complaint. You also really need to train your managers, because, like we mentioned earlier, if a supervisor does any conduct that is considered to be, discriminatory or retaliatory, that is imputed to the company. But also, they are your front line. They really are your front line of defense, because often it is the manager or is a supervisor that is going to be receiving that first complaint. So it is critical that your managers are also trained on your company's policies and reporting procedures, that they notify the company as soon as they hear of something, that they monitor the workforce and make sure that there isn't any conduct that could be problematic occurring, and that they respond promptly. And again, promptly is the word. So a lot of times, a manager will get, a complaint that doesn't sound that bad. It sounds like, hey, Joanna was, kind of mean to me the other day, and she made this comment about about Hispanics. So that would be probably very overt, but I was like, Joanna was mean to me the other day.
I just violated a few laws there.
Yeah. Well, that manager came like, well, I know Joanna didn't mean anything, but I know Joanna was just joking. That is the birth of a lot of the discrimination complaints that we get. So even more important than your workforce being trained is your managers being trained, right, and that they know how to recognize and properly elevate complaints.
Right. And I think that that's part of the hurdle, where I think that a lot of times supervisors think of the more traditional, like Joyce likes to call it, like the Mad Men type of situation, where it's very it's very in your face, but managers do have to be trained on, more of the situations where, coursing around turns a little bit, it turns a little bit, or they're using, like, certain supervisors and employees are using, certain derogatory terms, with each other, even if they're part of, the same, protected class. A lot of it goes to having the supervisors being able to identify, what are possible instances of discrimination and harassment and retaliatory conduct, and they know to report it and escalate it over to HR.
And kind of what we're getting at too here is that, discrimination is not always obvious. Like when we think of discrimination, we often think of like the workplaces of the 50s and the 60s and the 70s where, there might have been, a really handsy, partner, or really, in derogatory terms used that are really shocking, that would be shocking for us here today. But discriminatory conduct is very often covert, and it can be very subtle. Here, there's some examples on the screen. So like somebody of a certain class who is passed up a promotion even though he's been there the longest. And there's often other reasons why someone is not promoted, but these are often the birthplace of these discrimination complaints, because they feel as if that hey, I am the most qualified. Why wasn't I chosen for this? And there's other things that you can do to prevent that, such as, really clear performance management. But this is what it often looks like. And you want to be careful to not overlook conduct where, an employee was joking, or if they didn't mean to offend anybody, if two people were just teasing each other. A lot of times two employees are completely fine with the conduct and they are just teasing each other, but it's a third person who's overhearing the conduct and becomes uncomfortable and then raises that issue to HR.
Absolutely. And, one thing that I have seen in California, at least, is the idea of promoting, hey, if you're a parent, that's a protected class in and of itself. And so let's say that you need to bounce out of work early because you have childcare or something like that. I don't live in that world, but let's just say that it is. At that point, an employer shouldn't be discriminating against you. And so, again, sometimes, I've seen on performance reviews, hey, because she's, a parent and also working here full time, sometimes her parenting duties get in the way. Notice how I say her and not him, because that's usually the way it turns out. But, you do see that. Also, there's a lot of benign comments and actions. When do you plan to retire? We need young blood. I've seen lawsuits where a supervisor who's younger, than the plaintiff employee says, we need young blood here. Hey, we're old school, fellas. And that ended up in a discrimination lawsuit. Advertisements for recent college grads, that could be viewed as discriminatory, even if you are looking for people who just graduated and are at a beginner level. Looking at, somebody's physical attributes, where, sometimes, nice comments and compliments, they could go a little bit too far. It's one thing to be like, oh, your hair looks nice, after, let's say you style it. But let's say if, it's like, oh, that is a very figure flattering dress. Oh, okay. It might be going a little bit far. These are a little bit more obvious. The Confederate flag. Yeah. You people. Yeah. Where are your people from? Another one is your English is so good. And so that could be viewed as discriminatory as well.
And, and I've had cases where, commenting on someone's like religious beliefs is what formed the basis of a discrimination complaint. Like not that, I think it was this past year. It was a Muslim employee who was not, who was fasting, I think during Ramadan, and another employee and, their manager organized an office lunch and was like, why aren't you eating with us? So like, it is sometimes very benign comments like that, that will be the meat and potatoes of someone's discrimination complaint. That, very frequently happens, and it happens a lot, especially with, with gender. a lot of gender complaints are have to do, like Joanna said, with like somebody with a parent needing a flexible schedule, or excluding like women from certain outings, and even
Which you could
making
exclude me from
assumptions.
golf, that's fine.
Yeah, I
but,
can't golf.
but voluntary. But yeah.
Yeah, but also, and then making assumptions about, career aspirations. Oh, this employee, oh, she just got married, so I think she's gonna want to start a family, and then like maybe not putting into account direct performance, and putting into those other outside, subsidiary factors that might be informing some of your personnel decisions.
Yeah. And then one thing that I've seen a lot more of is, especially in the last 10 years, there's been a lot more people coming out, as transgender, going through gender affirming surgery. And usually the first step there is, they'll change their pronouns. It might be a they or the opposite gender. They may change their names. They may change their clothing. But I've seen a lot of employers have a lot of difficulty, in addressing that kind of situation, especially because sometimes it's not as straightforward as somebody would like. Where let's say that somebody, is kind of flip-flopping back and forth, with genders. They're trying to explore, what it's like. Okay, well, you should really try to address them by their preferred pronouns, their preferred name, and honor that to the extent that you can, because if you don't, then that could be, a basis of a discrimination complaint. I've seen them. I think the first one hit in 2012, and we just see more and more of them.
Yeah. So now that you've received an internal complaint of discrimination, retaliation, or harassment, so what do you do? So we're going to go over some of the best practices that you should undertake. So first and foremost, you take these internal workplace investigations are really necessary to discover, address, and prevent workplace problems. And one of the most important things that you need to do in this list is decide who should conduct the investigation. Oftentimes, like, it's somebody who has like history with a lot of times, they'll pick somebody. The company will pick an employee in HR who has a long history with this with the complaining party. And maybe the complaining party has complained about this HR rep in the past. So it's stands to reason that maybe that person might be biased, and if that's the case, somebody else should do the investigation. And there's other methods you could take as well.
Absolutely. And one thing that you want to keep in mind is, different people, do conduct these investigations. Sometimes there's somebody especially trained in HR or, an ethics type of department, within a company. Not all companies are the same. But a lot of times employers want to use their outside counsel to conduct these investigations. It really depends. But one thing that you need to keep in mind is if you already like your employment counsel and they conduct the workplace investigation themselves, usually your conversations with them totally cloaked by privilege, they're confidential, but that is not the case in the context of a workplace, investigation. And so you might not be able to use your counsel if you are sued down the line. If you do have a preference, for a certain attorney or a law firm, they might be prohibited from participating because they essentially almost became not a witness, but, they were involved with the investigation itself. That being said, a lot of times I get this very frequently where, a client will call me, on the spot or send me an email. Hey, can we talk in the next 2 days? I'm handling a workplace, investigation. And I kind of want to just get your thoughts. At that point, everything is privileged, and I can tell them, hey, this is how I think, here are my thoughts on how to handle it. And we come up with a solution together. But it is important to see who you're going to pick. A lot of times employers want to go with a third-party investigator. They're expensive, but they do their job very well, assuming you pick the right one. But they do it very, very well. They're used to talking to employees from all walks of life. They can choose the right avenue, to conduct the interviews in. Is the employee going to be more comfortable with a Skype interview versus or a Zoom interview versus, in person? even down to their appearance and how, you know, they're going to present themselves over to the employee. Also, whenever there is a workplace investigation, you always, whoever does conduct it, they need to know, they need to start out the entire conversation by saying, this company has an anti-retaliation policy, and make that rock solid.
Yeah, year after year, the number one charge that the EEOC gets is not based on, is not race, it's not gender, it is retaliation. That is the biggest liability for employers, is how they acted after an employee, after they received a complaint, and what happened then. So, in talking about some of the best practices for when you are conducting your investigation, I think the most important thing for, if you're choosing someone who if you're designating somebody within your company to do these, they need to make sure that they're asking non-leading, non-judgmental, very open-ended questions. Accusatory questions is not going to get the responses that you need to conduct a thorough investigation. And they're likely to put the witness on the defensive. So if I were to ask, hey, Joanna, did you sexually assault Joyce at the Constangy holiday party? And Joanna is not going to say yes. But if you ask, hey, Joanna, could you describe your interaction with Joyce at the Constangy holiday party? That is a lot more preferable. And that's going to require a narrative instead of a yes or no answer. And it's not going to immediately put someone on the defensive. And that goes for everybody. And you want to get to, the who, what, when, where, why. You need to find out documents that might relate to the situation, that might corroborate the claims, or to the contrary.
And please preserve all of them.
Yes. And
also,
again,
yep.
Yeah, and really important, avoid legal terms and phrases. Like, the fact finder needs to act exactly that, and saying this person said this person said that, and just get the facts. You don't want to say, Joyce sexually assaulted or sexually harassed Joanna, or Joanna discriminated against Joyce. You need to describe the conduct in as factual of terms as you can.
Right. Or even saying something like, so-and-so suffers a disability, and then they decided to engage in the interactive process and they requested an accommodation. You don't want to use language that specific. You just want to put it in the employee's words. This is what they said. And then this employee said that, and so it's almost like you let the employee draw the conclusion and not you. Let the, lawyers, if need be, do that job later on. Just let the employee form the conclusion, there. Another thing I want to say is choose your witnesses as well. A lot of times there's a written employee complaint where it kind of defines the scope or the blueprint of the workplace investigation. However, you might want to interview more witnesses, but then at that point, there's going to be more employees talking, and the chances of you asking, hey, please keep this interview confidential to the extent that you can, that's likely not going to be honored at that point. So I just wanted to point that out.
Yeah, and even when you're considering witnesses, a lot of times employers don't want to talk to people who have left the company, but there's no reason why you can't. And in fact, the case that I took to trial last June dealt with exactly that. One employee claimed that East Asian employees are being discriminated against, and two had left the company. And as part of their investigation, the company decided to not interview those other witnesses. And that's something that, you should discuss as a strategic matter, but, you don't have to limit the investigation to people who are within the company.
Absolutely. And so I know that we're out of time, and so I do apologize for that, but Joyce and I really like discussing this. I think that it's fascinating, and it's definitely a puzzle. But let's just go over some key points, to finish up the PowerPoint slide, where, again, documentation is everything, kind of like written policies. You want to keep that litigation perspective. You want to act like a jury is watching you now and not later, without forming legal conclusions. You really don't want to form those conclusions. You want to be fact driven. You want to be accurate. You want, for each interview, you want to be taking notes, contemporaneously. Sometimes, employers want to record the interview, and it depends on really what state you're in. Sometimes employees or witnesses want to record that interview. That presents an issue because sometimes the employer doesn't even know about it and they don't know what the employee or the witness is going to do with the recording after the fact. But generally speaking, what you want to do is identify the documents that are relevant. You're probably going to have to obtain more documents that become relevant as you conduct witness interviews, and you want to preserve everything, because this is where I get mad at clients where they don't preserve stuff and they had it before. That's the most frustrating thing, and that can lose a case.
Yeah, and also think about, what a jury sees. So juries is going through a trial really changed my perspective on, how to conduct an investigation, because juries expect that the discipline was justified, that the employee had fair notice, and that the decision was fair. And that goes back to your policy. That goes back to performance management, what you told the employee throughout the investigation. And
Absolutely.
you want to keep those things up in front of mind.
And then another big thing is the timing of the investigation. You want to be prompt. It can't be, oh, well, HR was on vacation for, they were in Hawaii for a week, so sorry. You really want to address, these concerns as promptly as possible. Granted, I've had a big third-party investigation with a client before that took 2 months. But the thing is, we were arranging interviews. It was a pretty big kerfuffle, and I'll leave it at that. But it did take months, 2 months to do, because there also needed to be time for the expert report. But we did show, hey, we retained the third-party investigator promptly. We were, sequencing these interviews. We were waiting on one employee that was gone on leave. And we had to accommodate, loaded term, we had to, basically wait until he came back from leave to interview him because we didn't want to disturb him while he was out on leave. So, you also want to be able to communicate, with the accuser, the complainant, as well as the accused. You want to consider, okay, for the time being, do I separate them out, different departments, or, am I going to place them on administrative suspension? And to the extent that I do, am I going to pay them during this time or not? These are all, things that you need to do during the workplace investigation, and hopefully that leads to a good resolution.
Yeah, and and if the allegation is corroborated, sometimes employers think the only thing you can do is terminate. You should look at discipline as a buffet. There is so many options. You can give a first-time warning, a last chance agreement. You can suspend, you can demote. There's other things that you can do other than just terminate.
So long as the written policy provides for it.
Yes.
I'm probably annoying everybody here.
Yeah, and even if the allegation is disproven, then you need to inform that employee who made the complaint. But there's also things that you can do that will make an employee feel heard, and such as telling them that there's going to be ongoing monitoring, that maybe take other remedial measures like change a reporting relationship or do a workplace training to just refresh your workforce on your policies, which again is all, we always go back to those policies because they really are your first line of defense.
Right. And I will say a lot of times, after a workplace, investigation, the results are inconclusive. Everybody's saying different things. It's a he said, she said type of thing. And, there's witnesses on both sides or there's no witnesses at all. And so at that point, to the extent that, the employer decides not to terminate and they're like, hey, look, nothing came up, but here's what we're going to do, is at least it shows, look, we're taking a proactive approach. We're doing something about it and we're going to monitor it moving forward. And that is, the way that, if you're hit with a lawsuit or you want to prevent these lawsuits from happening in the first place, a lot of times my motto is happy employees don't sue. Usually employees are happy, whenever they do feel heard. And sometimes it's a little bit burdensome to go through the normal rumor mill, whatever drama complaints, but it is well worth it at the end. So thank you.
Yeah. And thank you all. As you could tell, Joanna and I can talk about this all day.
Yeah.
So connect with us.
Yeah. And so if you want to join us until,
Yeah.
4 p.m. Pacific,
Yes,
kidding.
if you want to get into more specifics, connect with us at your peril.
This
This
was
is
actually
like,
pretty short for us. So,
yeah.
but we love discussing these topics is because I love prevention. We love prevention. We feel like we're
Yes.
helping, rather than, dealing with annoying plaintiffs' attorneys. And so, yeah, but, please connect with us. Please let us know if you have any other ideas for presentations. I know that numerous questions came in. We are out of time, and a lot of them are very fact specific, but what we're going to try to do is answer them, to the best abilities possible without knowing the context of it. But we will, circle back on those because unfortunately we are out of time because Joyce and I like to talk about this. So anyway, I do appreciate it. And yeah, please fill out the survey and we will be in touch.
Yeah, and thank you so much.
Thank you.